should not be left in quarantine centers alone. A relative should be allowed to stay with them. Strict sanitary precautions should be taken at all times, and during the transport of patients, and a proper logbook should be kept in the vehicle. Operational guidelines at all levels of care for epidemic outbreaks should be in writing, circulated and updated according to the epidemic conditions and prevailing WHO guidelines. The monitoring committee noted that there are 8 dialysis machines which can dialyze a total of 48 critically ill COVID-19 positive patients, and CT scan facilities are provided at New Suivez Hospital. A public relations desk would be provided at each hospital with a healthcare assistant specialized in public relations. Furthermore, an undertaking was issued to relatives willing to stay with the dialysis patients during their quarantine period. All sanitary measures are being respected at the dialysis units, and operational guidelines have already been established and are being put into practice. Lastly, the fact-finding committee made recommendations on patients' education and recommended that dialysis patients should be informed about the risk of COVID-19 infection, and all information related to COVID-19 should be made accessible to them. Telehealth options should be promoted so that patients can get appointments, medical advice, and other information over the phone or computer. The monitoring committee was of the view that sensitization campaigns are being conducted by the ministry to educate immunocompromised patients about the benefits of vaccination. With regard to telemedicine, I wish to inform the House that this recommendation will need further consultation and amendment in legislation before its implementation. Mr. Speaker, sir, the committee overlooking the implementation of the fact-finding committee's recommendation has concluded that more than 90% of the recommendations have already been implemented. All the above recommendations pertain to the improvement of the dialysis service in my ministry. The remaining 10% of the recommendations to be implemented is mainly for telemedicine options, where patients can get appointments and advice online. Mr. Speaker, I am informed that the fact-finding committee started its operation on 5th May 2021 until 16th December 2021. The fact-finding committee has held 25 sittings. The chairperson, the 2 assessors, and the secretary would be paid as per established fees set by the Peer Research Bureau and the Ministry of Public Service, Administrative and Institutional Reforms. The chairperson is paid 4,650 rupees per sitting, and the assessors 50% of the fees payable to the chairperson, and the secretary 30% of the fees payable to the chairperson. I am also informed that the members have not yet been paid. Mr. Speaker, in regard to the findings of the fact-finding committee, it should be noted that they are mainly of personal and individual nature. I further wish to inform the House that the recommendations of the fact-finding committee's report on the improvements to be brought to the dialysis services in the ministry, there have not been any conclusions that have pointed towards acts of negligence at the level of the New Suivez Hospital and the Tamasa Hotel Quarantine Center in the report of the fact-finding committee. Mr. Speaker, sir, the report will not be made public, as these cases have been referred to the Medical Negligence Standing Committee for an inquiry to be conducted on a case-to-case basis so as to determine whether there have been any cases of alleged medical negligence. Mr. Speaker, sir, moreover, the medical health professionals are regulated by authorities such as Nursing Council, the Pharmacy Council, the Allied Health Professional Council, and the Medical Council. These bodies operate within specific legislations. In addition, such cases of alleged medical negligence can also be referred to the medical tribunal, which is chaired by a sitting judge, and it is his mandate to determine any act of medical negligence. To conclude, Mr. Speaker, sir, unlike for a commission of inquiry, a fact-finding committee has no statutory basis, and the persons who produced the report and the witnesses before the committee are not given any legal immunity. You will understand that divulging the fact-finding committee's report may put these persons at risk of litigation.
I would advise ministers not to launch 8 questions in one reply. This becomes very boring, so your chief executive has to take note of that. Honorable Juman.
Thank you, Mr. Speaker. I heard the...
You did? One by one. He's a lawyer. He knows how to defend himself and make his case. Please.
Speaker, sir. Mr. Speaker, sir, on 20th of April 2021, the Honourable Minister of Health refused to give a fact-finding committee. And today he's refusing to table the report of the fact-finding committee. He's also refusing to tell the House the finding of that committee, despite us having paid hundreds of thousands of rupees to that committee. So what we would like to know, Honourable Minister, what the parents of deceased people want to know, has there been any finding as to how 11 people who did not have COVID went to treatment in a dialysis center under your ministry, caught COVID, and died?
Mr. Speaker, sir, in my reply, I've already given the reasons why the fact-finding committee's report cannot be made to the public. And at the same time, I've already also mentioned that what are the different statutory bodies that can deal with cases of medical negligence. Now, Mr. Speaker, sir, this is not the first time that fact-finding committees' reports are not made to the public. If you can recall, in the past, you have so many reports of fact-finding committees under different governments that were not made to public. I just can recall 2 committees, the Committee on the MITD, which was submitted in March 2013, which was not made public. The report of the fact-finding committee of D.Y. Patel Medical College was never made public. So this is not the first time, Mr. Speaker, sir. Horse racing report, also. There are so many reports that haven't been made public.
Order. Honorable Juman.
Thank you, Mr. Speaker. Honourable Minister, why the matter should be referred to medical negligence when the purpose of setting up the fact-finding committee was to inquire into and report whether there has been any act of negligence which led to death? So why, despite having the fact-finding committee report, you're referring the case to a medical negligence committee? Has there been any case of malpractice or whatever which should be referred to police? That's why you don't want to let the report, make the report public?
Don't impute motives, put question.
Mr. Speaker, sir, again in my replies, I've already given the reasons why the report, the recommendations of the report is more on the improvement of the services, and there are already statutory bodies where they can inquire and give their reports, their recommendations, but whether there is an act of negligence or not. Mr. Speaker, sir, I've already met the relatives of the patients who have disease. I've already explained to them, the diseased patients, I've already explained to them about the report, and they all have agreed that these individual cases, individual experiences, individual complaints have to deal with the different councils, with the different regulatory bodies.
Thank
you very much, Mr. Speaker. Is the Minister aware that the relative of the deceased and those who are still undergoing renal dialysis have agreed to waive their confidentiality to make sure that the report is rendered public in the name of transparency and accountability?
Mr. Speaker, sir, I've already given that reply. I think I have to read it again. that the fact-finding committee has no statutory basis, and the persons who produce a report and the witnesses before the committee are not given any legal immunity. So you will understand why this information cannot be made to the public.
Thank you. From the Minister's reply and listening to the 4 recommendations that you have enumerated from the fact-finding committee, it appears that the blame of those who died lies solely at their feet because they refused to come for vaccination. Therefore, can I ask the Minister whether, as part of the whole setup of looking dialyzed patients, whether his ministry failed to provide adequate medications such as remdesivir, tocilizumab, antivirals in March 2021, which led to their demise?
Mr. Speaker, sir, this is the honourable member observation that these patients haven't come to do their vaccination, and that's have caused their serious state. This is his observation. This is not mine observation. There is a committee, there is a fact-finding committee who has given its report, and I've already given all the main headings of those reports. And now in the question of the drugs, so I believe the honourable member can accompany the patient's relative to attend the different complaints whenever they will be taken by the medical negligence standing committee, and he can always give his views to that committee, and then let the committee, as a body corporate, do their report, and then we'll submit the report. We'll go according to the report. We are not here to make, to start making any judgment on what has happened or what hasn't happened there.
Honourable Dillard.
Thank you, Mr. Speaker, sir. Can the Minister inform the House, if ever he has any comparative data, on the mortality rate amongst dialyzed COVID-19 patients in Mauritius compared to that of other developed countries? Thank you.
Mr. Speaker, sir, compared to the mortality rate among COVID-positive patients in Mauritius, it stood at 13%, and 13. In Réunion Island, during the same period of time, it was 15%, according to the nephrologue en charge of the Réunion CHU, Professor Vacher Kupuna. Now, international medical literature also shows that the percentage of non-vaccinated dialyzed patients getting infected with COVID-19 and passing away varies between 20 to 28%, including in developed countries. The rate in Great Britain is 20%, 25 to 26% in USA, and 28% in the province of Ontario in Canada. So I'll table the literatures where you can get this information precisely.
Honourable members will bear with me. There are 8 questions lumped in one reply. So I have to give an opportunity to each and one mover of the question. Honourable Fouquioun.
Merci, Monsieur le Président. Peut-on savoir si l'honorable ministre va considérer rendre publique une version qui soit expurgée de ces informations qu'il dit classifiées?
Mr. Speaker, sir, in my reply, I've already given all the recommendations of the committee public, so you'll get it in Hansard.
Honourable Lobin.
Yes, thank you, Mr. Speaker, sir. Can the Honourable Minister inform the House if he has obtained legal advice from the State Law Office if this report of the fact-finding committee cannot be tabled before this House and cannot be made public? Does he have a legal advice to that effect?
Yes, Mr. Speaker, sir. That's why I could read it loudly. That's why I've given the conclusion of this report. This is from the State Law Office.
Oui, merci, Monsieur le Président. Monsieur le Président, le fait de référer justement le rapport du Fact-Finding Committee au Medical Negligence Committee pour enquêter, n'est-il pas justement un aveu qu'il a bel et bien eu négligence médicale à l'égard des 11 patients dialysés qui sont décédés?
Mr. Speaker, sir, so the fact-finding committee, based on the setting up of the fact-finding committee, according to what has been their terms of reference. Now, that has been the report, but at the same time, we cannot bypass the other institution that will deal with the complaints. So if in that report we would have the questions that's been raised, whether there is medical negligence, whether these patients haven't given proper care of, if it would have been taken into the recommendations of the report, obviously, there would have been no point of sending these, the patients to the different committees, that is the medical negligence committees, or to the other committees. But the report is what I've given you, the recommendation, and at the same time now, on individual cases, these individual cases have to definitely, the complaints have to be lodged to the medical negligence committees, because I believe you will understand that every relatives have different complaints, and that should be dealt with those committees where they can specifically determine whether there is negligence from the nursing side, from the doctor's side, or for any others. So we have to do this part of the job. I'm sure that, and that would be because now we are also public officers. They are also recruited by the Public Service Commission. So you have to follow the proper procedures before determining whether there is a negligence or not.
Next question.
27.
Mr. Speaker, sir, prior to the 1st of July 2020, the process for the transfer of ownership of a vehicle was quite time-consuming for customers, as it involves different procedures undertaken at the level of the NLTA, which is situated in Cassis, and the Registrar General's Department, which is based at the Emmanuel Anchil building in Port-Louis. With a view to reducing this processing time and facilitating the transaction, the sub-office at the Emmanuel Anchil building was introduced by my ministry on the 1st July 2020 as a one-stop shop facility to streamline the procedures. Both the NLTA and the Registrar General's Department are now sheltered under one roof. Thereafter, most customers call at the sub-office of the NLTA, situated at the Emmanuel Anchil building, for transactions relating to the renewal and payment of motor vehicle licenses, and more specifically for the transfer of ownership of motor vehicles. Some 715 such transactions are effected on a daily basis at this sub-office. The processing time of the different transactions depend on the type of transaction. The average processing time for the renewal and payment of MVL does not exceed 10 minutes. Mr. Speaker, sir, I am made to understand that initially there was no ticketing system in place at the Emmanuel Anchil building sub-office. However, since August 2021, a ticketing system has been installed thereat, and the waiting time for a transaction has been significantly reduced to 5 minutes or less.
Thank you, Minister. Can the Minister provide the figures with regard to the other units or other subsection compared to the Emmanuel Anchil branch?
Yes, Mr. Speaker, sir, I have the figures. In fact, the transfers at the other sub-offices are as follows. If I take the month of January of this year, at Plaine-Lausanne sub-office it was 848, at SGS Forest-Side 2,057, at the FLAC sub-office 1,813, and at the Emmanuel Anchil Port-Louis it was 2,619. But I must say that the figures remain high at the head office at Kasi, which amount to 12,877, which means, Mr. Speaker, sir, that if we did not introduce the Emmanuel Anctil building in Port-Louis, the head office at Kasi would have had to deal with 2,619 transactions more per month.
You have another one? Yes. Please go ahead.
Yes, thank you, Speaker. Does NTA have any place of internet or digitalize in your system so that people don't have to come physically to make queries?
Yes. In fact, this is a good question, Mr. Speaker, sir. In fact, the problem basically with the number of our citizens attending at the different NLTA offices is, Mr. Speaker, in fact, due to the increase of our fleet of cars. According to the statistics, Mr. Speaker, sir, in December 2020, our fleet statistics stood at 600,053. December 2021, our fleet stood at 622,988. In the year 2020, in the year of confinement, 23,452 vehicles were registered, Mr. Speaker, sir. And in 2021, last year, 24,947 vehicles were registered for last year, again, a year of confinement. So therefore, the NLTA has already embarked on the digitalization of its services, Mr. Speaker, sir. An online platform for the renewal of motor vehicles has been introduced. The system provides a 24/7 service to customers accessible from the comfort of their home. The phase 1 concerns renewal and payment of MVL for private vehicles owned by individuals only. But in fact, there are different projects. The motor vehicle license online, phase 1, phase 2. The phase 1 has been nearly completed, Mr. Speaker, sir. We are at the moment connecting the IT system of the Mauritius Post Limited and that of the NLTA to ensure updated information regarding motor vehicle license renewed at the post office. Testing is being finalized at the level of the Mauritius Post for payment to be shared by the Ministry and the NLTA. And there will be the introduction of the SBM gateway on the MVL online platform, pending the introduction of an integrated payment system, which will be shortly implemented by the Bank of Mauritius to further enhance payment modes and facilities. Then we will have the project which have been completed, Mr. Speaker, with regard to digitalization of the NLTA, is the online reservation of registration mark from FN to ZZ. This is completed. The online reservation for a new series of personalized registration marks up to 9 characters, that is your name on your plate. This also has been completed. And we are in the process of completing also the MVL online phase 2, which would consist of renewal of MVL in all types of vehicles, including taxi, contract car, bus, and AB carrier, Mr. Speaker, sir. This platform would enable more vehicle owners to renew their MVL online, especially, for example, during times of lockdown, for example. This would help to decrease the influx of public calling at the NLTA counters. Discussions are still going on with SIL with regard to the finalization of the scope of the project.
Thank you. The question has been canvassed. Thank you.
Okay. Next question.
B28.
Mr. Speaker, sir, I'm informed that the present board of the Mauritius Society of Authors is chaired by Monsieur Gérard Daniel Louis, OSK, and includes 7 ex-officio members, as well as Mr. Mewanan Takuri, MSK, who is a member having knowledge and experience in the field of copyright and related rights in line with the Copyright Act 2014. With your permission, Mr. Speaker, sir, I'm tabling the composition of the present board of the Mauritius Society of Authors.
Can the Honourable Minister just remind us of the initial composition of the board of the Mauritius Society of Authors?
With your permission, it would be easier for me to table the complete list, so I will provide it to the House.
Merci, Monsieur le Président. Peut-on savoir de l'honorable ministre quand aura lieu l'élection des artistes qui siégeront sur le board de la MASA?
Mr. Speaker, sir, the last elections were held in April, 22nd of April 2018, and the previous board reconstituted in May 2018. Elections, at the end of the mandate, elections were due in June last year, but unfortunately, because of sanitary restrictions and the fact that prior to any election, there has to be a General Assembly with a quorum of minimum 70 members. It was not possible for MASA to hold the election. So we are waiting. We have had discussion with the Electoral Commission. Last week, I personally met the chairperson and the director to discuss on the possibility. Of course, we will seek legal advice on this matter to see if we can, independently of holding a General Assembly, hold the election as soon as possible.
Thank you, Mr. Speaker. A Solidarity Fund was set up by the Mauritius Society of Authors in 2010 to support the artists. Can the Honourable Minister inform the House of the eligibility criteria? Thank you.
Mr. Speaker, sir, of course, this question is not related to the main question, but I will nevertheless provide some information on the Artist Solidarity Scheme, as mentioned, which was set up in February 2010 by way of decision of a board. The purpose was to provide a monthly payment of pension to artists at the age of 60. And the board at that time approved that the contribution of each member to the development of culture will be taken into consideration, together with the individual financial contribution towards the social welfare fund. So basically, these were the criteria at that time that were put in place to determine whether pension is paid or not. Right now, there is a subcommittee working on a revised set of criteria to ensure that we are able to accommodate more artists in this pension scheme. As at now, we have approximately 25 beneficiaries of this scheme, which is still operating as per the 2010 rules.
David?
Merci, Monsieur le Président. Le board de la MASA est donc amputé de ces 7 artistes élus depuis bientôt 1 an. Alors, on a bien compris la raison, ce sont les restrictions sanitaires. Pour autant, puis-je demander au ministre la raison pour laquelle le mandat précédent des artistes n'a pas simplement été prolongé jusqu'aux prochaines élections? Et donc, quelle est la légitimité du board actuel pour prendre des décisions au nom des artistes alors que ces derniers n'y siègent pas?
Mr. Speaker, sir, it would have been the practice if there were appointed members that their mandate be either renewed or extended pending election. But unfortunately, these 7 members were on board by virtue of an election. So by the end of their mandate, automatically, they no more form part of the board of MASA. Cependant, Monsieur le Président, il faut savoir que ce board comprend également un président qui est lui-même a very reputed and respected artist, en l'occurrence M. Gérard lui, but also another artist appointed by the minister, again by virtue of the law, qui est M. Takouri, another respected member of the creative industry. So, venir dire que la MASA est amputée des membres des artistes is not really correct, because we have today 2 members of the creative, of the music industry, who still form part of the board, and I think, je suis tout à fait d'accord que cette balance des artistes est la représentation administrative doit être respectée, but unfortunately, as I said, we are subject to certain sanitary restrictions whereby we are not being able to organize the elections.
Président, par rapport à la nomination du directeur par intérim de la MASA, peut-on savoir si le board dans son ensemble a donné son accord ou est-ce un choix imposé par le ministère?
The board operates independently, and as far as I know, I've been informed that it was a unanimous decision of the board. Of course, I will need to refer to the minutes to be able to provide you with precise information, but all decisions being taken c'est à la base of the consent of all members. So I don't think I have any reason, any particular reason to think otherwise.
The table has been advised that PQB 47B 78 have been withdrawn. Next question.
B29.
Mr. Speaker, sir, with your permission, I will reply to PQ B29 and B100 at the same time as they relate to the same subject matter. The price structure of mogas and gas oil exists since several decades and has been used as a method of raising revenue. The price structure has evolved from the 90s when it contained elements such as stamp duties, ocean loss, construction of reservoir, road fund, among others, to what it is today. The contributions in the price structure of mogas and gas oil are fixed and do not change when prices of petroleum products are reviewed. The Association des consommateurs de l'île Maurice and other associations have made representations to the government to review the price structure and reduce the amount of contributions which are paid by consumers. Mr. Speaker, sir, it is important to note that when preparing the national budget, the Ministry of Finance, Economic Planning and Development imperatively has to forecast both expenditure and revenue. The revenue derived from the price structure finances a number of public projects, which includes maintenance of road, purchase of COVID-19 vaccines, provision of subsidies on gas cylinders, flour, rice, among others. And I'm sure that the honourable member would understand this crucial exercise because when the MMM was in power in 1996, a contribution was introduced in the price structure of gas oil for the construction of reservoirs. In view of the implications of the proposals, the matter is being thoroughly examined by the Ministry in collaboration with the Ministry of Finance, Economic Planning and Development.
Thank you, Honourable Minister, for saying that you're going to review the structure. Is the Honourable Minister aware that in December 2014, when the government took office, the retail price of mogas was 45 rupees, out of which 21 rupees were taxes and levies. Today, it is 61.3 rupees, out of which 30.2 rupees is taxes and contribution. So under your government, there has been an increase by 40% of levies, taxes, and charges. Do you find that acceptable, Honourable Minister?
This question, Mr. Speaker, sir?
Finding acceptable that under your government, the contribution and taxes on petroleum products have increased by 40%.
Yes, because several taxes have been introduced, specifically to finance the COVID vaccine and other items.
Monsieur le ministre, vous êtes bien placé pour savoir que la population souffre énormément ces jours-ci avec l'inflation des prix. Le ce levy, ces taxes sur les produits pétroliers ont été introduits depuis quelque temps et plus de 50% dans le structure de prix des produits pétroliers, 50% est des taxes. Est-ce qu'on peut prendre de votre réponse, Monsieur le ministre, que vous prenez l'engagement avec le ministère des Finances pour voir comment on peut revoir cette structure pour enlever ce fardeau sur les consommateurs et les ménagères?
Mr. Speaker, sir, the decision to introduce or remove levies or items from the price structure of gas and gas oil is a policy decision, and it is taken by the government. I cannot commit myself, neither can the Ministry of Finance, I'm sure. It is a collective decision which has to be taken by Cabinet.
Thank you. Honourable Minister, now that nearly 1 million people have already been vaccinated, we just heard, with 2 doses, and 600,000 already boosted ban, considering the number of COVID vaccines already in stocks, and we just, the Minister previously just mentioned 379 million rupees collected for the last 6 months, will you consider to waive the 2 rupees as tax on mogas and gas oil immediately?
Again, Mr. Speaker, sir, I cannot take it on myself to remove any levy or taxes. It will be for the government to decide, and I understand the point made. And I refer to the reply given earlier by my colleague, the Honourable Minister of Finance. We will give due consideration.
This question has been sufficiently canvassed. I move to the next question.
B30.
Mr. Speaker, sir, at the outset, it is worth highlighting that the right to draw water from rivers and canals in Mauritius is governed by the provisions of the Rivers and Canals Act of 1863 and the Central Water Authority Act of 1971. As per the Rivers and Canals Act of 1863, a right to use water from a river or stream for a specific purpose has to be brought before and decided by the Supreme Court of Mauritius. Mr. Speaker, sir, allow me to briefly enlighten the House on the background of the case before coming to the judgment delivered by the Privy Council on 14th February 2022, following hearing of the appeal on 10th June 2021. The appeal case basically concerns water rights in the river Tatamaka. Mr. Speaker, sir, in January 2004, the Central Water Authority had initiated legal proceedings before the Supreme Court of Mauritius on grounds that Shell and one of its group members, namely Tropic Nits Limited, do not hold proprietary rights over the water drawn and were using the water unlawfully. In fact, Mr. Speaker, sir, Réunion Sugar Factory Limited was allocated a water right in River Tatamaka by part of its land to Shell together with the water rights. Since 1989, Tropic Nits Limited have been diverting water from Tatamaka River without having applied to the Supreme Court. The CWA claimed that it was entitled to payments for the use of water from River Tatamaka via Réunion Canal for industrial purposes by Tropic Nits Limited, and that claim amounting to 4,958,071 rupees and 65 cents had remained due as at 30th November 2003. In a judgment dated 8th July 2016, the Supreme Court allowed the Central Water Authority's claim, holding that Shell and Tropic Nits do not hold proprietary rights over the water and were using the water unlawfully. Ciel and Tropicnits Limited appealed against this verdict, and the Court of Civil Appeal, in its judgment dated 12 September 2018, again dismissed, same ordering Ciel and Tropicnits to pay the Central Water Authority for the water used as from January 1994. Subsequently, in 2018, Ciel and Tropicnits Limited appealed to the Judicial Committee of the Privy Council. Mr. Speaker, sir, the main contentions of Ciel and Tropicnits were that, 1, they already own the water drawn from River Tatamaka and Réunion Canal pursuant to the 1888 order or by prescription. 2, CWA did not supply the water and cannot charge for water use. And 3, CWA's claim is barred by prescription. The Privy Council, in its judgment of 14 February 2022, and with regard to the ownership of the waters in the River Tatamaka and the Réunion Canal, held that a claim in prescription could not succeed because the waters of the rivers form part of the domain public. Further, under the Mauritian law, the right to a share in the waters of a river is not a right of property that the borderer owns and may sell or transfer. It was not private property or a private good. Thus, the only right of the borderers was a right of jouissance. For all these reasons, the Privy Council held that the appellants had not established any rights to the water in the river or the Réunion Canal. Mr. Speaker, sir, as for the entitlement of the CWA to levy charges on Tropicnits Limited for the use of water from River Tatamaka and the appropriate period of prescription, the Privy Council considered that the CWA was entitled to claim water charges from Tropicnits Limited from the date claimed, that is January 1994, on the strength of regulations prevailing under the CWA Act. It further ruled that the CWA's claim was not barred by prescription. Hence, on ground of all the above, the appeal made by Ciel and Tropicnits Limited was unanimously dismissed by the Privy Council. Mr. Speaker, sir, I am informed that action is being taken by the CWA following the delivery of the judgment. Furthermore, the amount due by Tropicnits Limited over the past 10 years is being finalized with the legal advisor and will be communicated to Tropicnits Limited for settlement. The water supply regulations under the CWA Act will further be amended to include a tariff for surface water. Mr. Speaker, sir, the judgment of the Privy Council is a landmark judgment in the administration of water rights in Mauritius. My ministry is consulting with the Attorney General's office on the policy implications of this judgment. Moreover, this judgment will be taken into consideration in the context of the elaboration of the water bill, which will be introduced in the National Assembly. I thank you, Mr. Speaker.
Thank you, Mr. Speaker, sir. Can the Honourable Minister inform the House of the volume used by holders of water rights?
Mr. Speaker, sir, records on water rights granted in the 18th and 19th centuries are scattered and incomplete, and as such have not been validated. But a rough estimate based on information on water entitlements and abstraction returns submitted by water users, so we depend on those submissions, can situate the volume of water pertaining to water rights to around 220 to 300 million meter cube per year, depending on the rainfall situation and any other climatic conditions prevailing. However, Mr. Speaker, sir, to allow for a better estimate, a proper assessment and monitoring mechanism need to be established, taking into consideration the changing circumstances and climatic situation. As I stated earlier, this mechanism would also be provided in the forthcoming water bill.
Thank you, Minister. In your answer, you mentioned some important years like 1863, 1971, whereby the Rivers and Canals Act and the CWA. I'm sure the Honourable Minister will agree that the land use for sugarcane plantation is decreasing and that water rights have been allocated since decades now. And will the government consider to review the water rights allocated for irrigation?
True it is, Mr. Speaker, as stated by the Honourable Member. Water rights were granted in the 18th and 19th century and were based on the climatic conditions prevailing in those days. Those climatic conditions are no longer valid due to considerable changes in the land use patterns and climate scenarios. Therefore, Mr. Speaker, sir, the growing scarcity of water resources and the daunting challenges due to climate change definitely impact on the water sector and call for us to revisit the existing water rights. These, as I stated, Mr. Speaker, and the preparation of the water bill, these fundamental objectives will be couched in that bill, which is under preparation at the level of my ministry to ensure the long-term sustainability of the resource in the best interest of the population at large.
The table has been advised that PQ B51, 61, 90, 93, 49, 66, 48, 65 have been withdrawn. Next question.
Stroke 31, please.
Mr. Speaker, sir, in these uncertain times of COVID-19 pandemic and international geopolitical turmoil, safeguarding food security is even more than ever crucial. I wish to assure the House that my ministry is working relentlessly to consolidate our food security policy. On the issue of land abandonment, this is not a new phenomenon. It has been present and persistent for decades. It has been exacerbated when the European Union reduced the price of sugar by 36%, and also with the abolition of sugar quota. On the sugarcane sector, Mr. Speaker, sir, with a view to reversing this situation of land abandonment and ensuring that our agricultural land is optimally cultivated, my ministry sought the assistance of the World Bank for review of the sugarcane sector. Following recommendations of the World Bank report, which have been made public, my ministry has implemented several measures to assist and encourage sugarcane planters to continue cultivating their land or even put their previously abandoned lands under cultivation. These include: 1, remunerating planters and producers at an increased rate of 3,300 rupees per ton of sugar produce, or 3 rupees 50 per kilowatt hour. And on this front, I am informed that a first payment has been effected to planters in December 2021. Second, maintaining the guaranteed price of 25,000 rupees per ton of sugar to planters producing up to 60 tons of sugar. Third, exempting planters producing up to 60 tons of sugar from payment of the SIFB insurance premium for crop 2021. Fourth, providing facilities to small planters under the cane replantation scheme to enable them to renew their sugarcane plantations and even bring back their previously abandoned land under cultivation. I am informed that as at date, 228 hectares of abandoned land out of a targeted 350 hectares for this financial year has been replanted. Fifth, investment in modern high-tech equipment and machinery to enable the planters community to benefit from timely and efficient land preparation and harvesting services. 6, providing planters access to certification and accreditation to sustainability labels and facilities to increase productivity of specialty sugars, which is more revenue generating. As regards the non-sugar sector, Mr. Speaker, sir, my ministry also provides a plethora of financial schemes to assist small planters. These schemes are intended to promote agricultural production and boost food security and curb the problem of land abandonment. A few of these schemes are: 1, acquisition of solar-powered coal room and CCTV cameras; B, purchase of agricultural equipment for the crop and livestock sector; 3, purchase of processing equipment and packaging, including design; 4th, fruit protection for banana bagging; 5th, refund on sheltered farming nets or plastic covering affected by natural calamity; 6, pasture development and cattle breeding; 7th, promotion of beekeeping; 8th, household gardening scheme. Furthermore, farmers are supported through various measures, such as: 1, allocation of a one-off grant of 20,000 rupees per ton on purchase of potato seeds; 2nd, guaranteed price for local wear potato and onion; 3, cash compensation for crop losses at the rate of 6,000 rupees per arpent for open field and sheltered farming for a maximum of 5 arpents; and 4th, a subsidy of 50% on the cost for buying fertilizer for one crop cycle at the rate of 7,500 per arpent for open field and a maximum of 10 arpents for sheltered farming. The House, Mr. Speaker, sir, may also take note that some 8,000 acres of agricultural state land falling under the purview of my ministry are currently leased to small food crop growers, livestock farmers, and cooperatives. In addition, 321 acres of agricultural state land have been allocated to Landscope Mauritius Limited to be leased to members of the public for agricultural purpose under the Land Bank program. Thank you, Mr. Speaker.
Thank you very much, Honourable Speaker. Can I ask the Minister whether he can give us an update on Land Suitability Index, and if he'll be able to tell us what is being done to prevent encroachment on prime agricultural land?
Unfortunately, for this specific question on the index, I will need the notice of the question. But I know if the honourable member is hinting at land speculation for other purposes, for example, residential, IRS, ERS, and all that, there is a statutory committee. It is created by statute which looks into land conversion. That committee is set up under the Sugar Industry Efficiency Act. It is chaired by the supervising officer of my ministry, and it's composed of a number of officers from institutions concerned with that. So the Land Conversion Committee, once again, which is a statutory committee, advises government, taking into consideration the issues of prime land, land under irrigation, and then, of course, the planning guidelines of the Ministry of Housing and the local authorities. All this is taken into consideration before an application is recommended.
The table has been advised that PQ B5 free, B7 free, B9 4, B4 free, B5 6, B5 8 have been withdrawn. Time over.
Motion.
Mr. Speaker, sir, I move that all the business on today's order paper be exempted from the provisions of paragraph 2 of Standing Order 10.
Is that seconded? Seconded. The question is that all the business on today's order paper be exempted from the provisions of paragraph 2 of Standing Order 10. Those in favor say aye. Those against say no. Aye. The ayes have it.
Statement by ministers.
Mr. Speaker, sir, I would like to make a statement on the outcome of the first visit organized by Mauritius to the Chagos Archipelago from 8th to the 22nd of February 2022. As the House is aware, following the advisory opinion of the International Court of Justice of 25th February 2019, which authoritatively determined that the Chagos Archipelago is and has always been an integral part of the territory of Mauritius, legal proceedings were initiated by Mauritius in June 2019 against Maldives under the United Nations Convention on the Law of the Sea for the delimitation of the maritime boundary between the two states in the Chagos Archipelago region, since Maldives refused our invitation to negotiate the boundary bilaterally. In December 2019, Maldives raised preliminary objections to the jurisdiction of the Special Chamber of the International Tribunal for the Law of the Sea, inter alia, on grounds that the sovereignty of Mauritius over the Chagos Archipelago had not been definitively settled, that the United Kingdom was an indispensable party to the case, and therefore the Chamber should not take any decision in its absence. Following the exchange of written pleadings and the holding of an oral hearing, the Special Chamber gave, on 28 January 2021, a judgment in which it rejected all the preliminary objections raised by Maldives. In so doing, the Special Chamber confirmed that Mauritius has undisputed sovereignty over the Chagos Archipelago. It further ruled that the United Kingdom has no claim to sovereignty over the Chagos Archipelago, and that its position amounts to nothing more than assertions that are not supported by international law. The proceedings are still at pleading stage. In the first round of written pleadings, Mauritius submitted its memorial on 25th May 2021, and Maldives its counter-memorial on 25th November 2021. During the second round of written pleadings, Mauritius will have to submit its reply by 14th April 2022, while Maldives will have to file its rejoinder by 15th August 2022. The Chamber will thereafter organize oral pleadings before giving its judgment, probably sometime next year. In the context of the preparation of its reply, Mauritius considered it necessary to carry out a scientific survey of Blenheim Reef, which is found in the northeast of the Chagos Archipelago, and which is likely to play a significant role in the delimitation of the maritime boundary between Mauritius and Maldives. Thus, a scientific survey was carried out from 8th to 22nd of February by a delegation led by Ambassador Kunjal, permanent representative of Mauritius to the United Nations in New York, and comprising technicians from Mauritius, 2 Swedish marine surveyors, 3 of our external lawyers, 5 representatives of the Chagosian community, a medical health officer and a nursing officer from the Ministry of Health and Wellness, a photographer from the Government Information Service of my office, as well as journalists from the British Broadcasting Corporation, The Guardian, the Atlantic Magazine of the United States, and the Mauritius Broadcasting Corporation. It was initially planned that the delegation would leave for the Chagos Archipelago from Maldives, and to that end, Mauritius requested the Maldives authorities to facilitate the visit. Regrettably, the Maldives imposed conditions that were not acceptable, including exclusion of lawyers, media representatives, and other officials. Consideration was then given to the departure of the delegation from Rodrigues. However, the captain of the vessel advised that the journey would be very tough if the delegation would depart from Rodrigues. As a result, the delegation left for the Chagos Archipelago from the Seychelles on 8 February 2022. For this expedition, government chartered the Bleu de Nîmes, which met all our requirements for this kind of survey, because it is equipped with 4 high-speed tenders and a Zodiac which allowed the scientists to traverse the shallow waters on and around Blenheim Reef. Mr. Speaker, sir, this was the first visit that Mauritius organized in the Chagos Archipelago since our independence, and I am pleased to say that the visit has been highly successful, as it has enabled us to achieve 4 key objectives. First, collection of crucial data. Mauritius has been able to collect crucial data for the maritime delimitation case which it has brought against Maldives. This data will assist both Mauritius in preparing its reply and the special chamber in delimiting the maritime boundary. The survey of Blenheim Reef and appurtenant areas was carried out over a period of 4 days, from 13th to 16th February, by the 2 foreign surveyors, Mr. Ola Oscarson and Mr. Thomas Menadal, with the help of high-end equipment to measure the tidal movement and to observe drying reefs and corals. Their report will be used in our submission, which is under preparation and will be submitted next month. For their part, officers of the Department for Continental Shelf, Maritime Zones Administration, and Exploration of my office observed the currents and waves on the outer edge of Blenheim Reef, as well as other visible formations, and took pictures of fishes and coral formations underneath the sea and on the seabed. I must point out that there has never been any such survey in the past, and I express the hope that the survey might assist the ITLOS Special Chamber. Second, confirmation of our sovereignty over the Chagos Archipelago. The visit has allowed Mauritius to confirm its sovereignty over the Chagos Archipelago, particularly following the advisory opinion of the International Court of Justice and the judgment of the Special Chamber of ITLOS. In this regard, the following concrete actions were taken in the exercise of our sovereignty. The flag of Mauritius was raised on the vessel to indicate the vessel's destination. On 11th February 2022, when the vessel entered the exclusive economic zone of Mauritius around the Chagos Archipelago, the captain marked the event by making the siren of the Bleu de Nîmes resound several times. As the vessel approached Peros Banos, foreign nationals who participated in the visit were handed a permit which had already been prepared by the passport and immigration officer for their admission to the Chagos Archipelago, a part of the territory of Mauritius. The flag of Mauritius was raised on Peros Banos, Solomon Islands, and Blenheim Reef. A commemorative plaque was also installed by the Mauritius delegation on Peros Banos to commemorate its visit there. Signs posted by the British authorities purporting to establish regulations for visitors were removed. An outward port clearance was given to the vessel Bleu de Nîmes on its departure from the Chagos Archipelago by the Mauritian authorities. And a health clearance certificate for COVID-19 in respect of the participants and the crew of the vessel was also issued by the Mauritian health authorities on their departure from the Chagos Archipelago. Third, visit of the Chagosians to their place of birth. I am pleased that government was able to keep its commitment to take some members of the Chagosian community back to their birthplace. The visit has provided the opportunity to representatives of the Chagosian community to return to their birthplace for the first time without any foreign escort or restrictions, and without having to be told where they could or could not take photographs. It was with great joy and enormous satisfaction that the representatives of the Chagosian community set foot on Île du Coin, which was the first stop on Peros Banos Islands, and which also was the island on which Mr. Olivier Bancou, Mrs. Marie-Lisby Élysée, and Mr. Marcel Humbert were born. The delegation was able to visit what is left of the church and the cemetery where some of the ancestors of the Chagosians are buried. Both of these places were in a deplorable state, and the representatives of the Chagosian community were able to clean them and restore the dignity such places deserve. A similar exercise was carried out on Solomon Islands, where Mrs. Rosemonde Bertin was born, much to the satisfaction of the Chagosians, who were able to pay their respect and homage to their ancestors buried there. Mrs. Suzelle Baptiste, born on Diego Garcia, was also part of the delegation. Fourth, uncovering the untruths spread by former officials of the UK. The visit has received a significant coverage in the international media. The journalists from the British Broadcasting Corporation and The Guardian sent out daily reports of what they saw on the islands, which contradicted the narrative that the United Kingdom has maintained over the years. In particular, that the Chagosians were in the Chagos Archipelago as contract workers and that there was no permanent population. The Atlantic magazine will, in due course, publish an article on the visit. The visit was widely reported in other international newspapers and media. This coverage has created greater awareness in the international community and, in particular, British citizens about the violations of international law committed by the United Kingdom, which illegally excised the Chagos Archipelago from the territory of Mauritius prior to its accession to independence, and forcibly removed the former inhabitants of the Chagos Archipelago, as well as the United Kingdom's continued breaches of international law. Mr. Speaker, sir, I wish to also inform the House that as soon as the vessel reached the Mauritian exclusive economic zone of the Chagos archipelago, it was observed that 2 British vessels traveled from Diego Garcia in the direction of Bleu de Nîmes, and one of them, which was identified as the Grampian Frontier, a patrol fishing vessel hired by the so-called British Indian Ocean Territory, in effect shadowed the movements of the Mauritian chartered vessel. It was clear that it was monitoring the activities of the Mauritian delegation, this despite the fact that following a note verbal which Mauritius had addressed to the United Kingdom, asking for confirmation that it would not in any way interfere with the Mauritian expedition. It had assured Mauritius that as a country respectful of UNCLOS, it would not impede the expedition. These vessels entered the territorial sea of Mauritius in manifest violation of international law. Government has protested against the presence of the United Kingdom vessels. The UK has sought to deny that its vessels were monitoring the activities of the Mauritius delegation. Upon the return of the delegation, following a question in United Kingdom Parliament, the Minister of State at the United Kingdom Foreign, Commonwealth and Development Office replied that the flags which the Mauritian delegation planted on the islands had been removed, and that the United Kingdom was disappointed that we had turned a scientific survey into, I quote, a political stunt, unquote. Let me say right away that far from being a stunt, this expedition has brought to light the dishonesty, the untruths, and disinformation which the United Kingdom has wanted the world to believe for so many years. Government also unreservedly condemns the unlawful entry of the United Kingdom into the territory of Mauritius and the removal of the Mauritian flags from the Chagos archipelago. Such an act has been committed in blatant violation of international law. A note of protest has been sent by the Ministry of Foreign Affairs, Regional Integration and International Trade to the UK Foreign, Commonwealth and Development Office to convey the strong objection of Mauritius to the removal of its flags from the Chagos archipelago. At a time when the United Kingdom is protesting Russia's occupation of a part of the territory of Ukraine, it is a manifest hypocrisy for the United Kingdom to seek to continue to illegally occupy a part of the territory of Mauritius and the continent of Africa. I need not point out that the scientific survey was carried out in a part of the territory of Mauritius, as authoritatively determined by the International Court of Justice in its advisory opinion of 25th February 2019, and confirmed by the United Nations General Assembly Resolution 73/295 and the judgment of the Special Chamber of the International Tribunal for the Law of the Sea of 28th January 2021. The actions taken by Mauritius during the scientific survey, including the raising of its flags in the Chagos archipelago, are fully compatible with the exercise of its sovereignty over the Chagos archipelago. Mr. Speaker, sir, I would like to thank Seychelles, and in particular, His Excellency President Wavel Ramkelawan, for all the assistance they have extended to us for facilitating the organization of this visit to the Chagos Archipelago. To conclude, may I say that government intends to organize other visits to the Chagos Archipelago in the future, and I very much hope that I will be able to participate in one of those visits. In addition, I reiterate that government is fully committed to the implementation of a program for resettlement in the Chagos Archipelago of our nationals, particularly those of Chagosian origin who were forcibly removed from their homes in manifest violation of international law. I once again call on the United Kingdom to get on the right side of history and to abide by the rule of law and the pronouncements of the International Court of Justice. Thank you. Mr. Speaker, sir, with your permission, I propose to make...
What is happening now? Nobody has the floor except the minister. Please.
Speaker, sir, with your permission, I propose to make a statement on the ongoing Russia-Ukraine conflict, which has ushered the world in an unprecedented period of instability since its outbreak on the 24th of February 2022. The conflict between the two largest European countries, which has entered into its second month, threatens the foundations of international peace and security with far-reaching consequences. Mr. Speaker, sir, at the outset, I would like to emphasize that my ministry has been closely following the escalation of tensions over the borders of Ukraine since December 2021. The flurry of diplomatic exchanges between Russia and the Western countries has from January 2022 failed to find a path for a peaceful settlement. Indeed, on the 24th of January 2022, Russia recognized unilaterally the self-proclaimed Donetsk and Luhansk republics in eastern Ukraine and announced the launch of a special military operation against Ukraine. There was an immediate condemnation of the military intervention by the UN Secretary General, the EU, and by NATO countries, where the issue was taken up at the UN General Assembly on the 4th March 2022. Mauritius voted in favor of the resolution condemning the aggression against Ukraine, which was overwhelmingly adopted by 141 votes. The decision of Mauritius was in accordance with the UN Charter and based on our attachment to the basic principles of our foreign policy, namely the respect for the territorial integrity and sovereignty of all states, the inviolability of frontiers, and the need to refrain from the threat or the use of force against any state. Mauritius has always favored peaceful coexistence and the settlement of disputes through negotiations. Mauritius was guided by the same principles when the UN General Assembly adopted a resolution on the humanitarian consequences of the aggression against Ukraine on 23rd March 2022. Moreover, we took the same stance at the UN World Tourism Organization, the Francophonie, and the Interparliamentary Union. Over the years, Mauritius has been consistent in its approach. Whenever any of the fundamental principles of our foreign policy were at stake, be it in Kosovo or in the pursuit of our struggle over the Chagos Archipelago. As the conflict unfolded, I had several meetings with the ambassadors of France, the United Kingdom, the European Union, the United States, and Russia, explaining our position and urging for the resumption of dialogue as a way forward. While the present conflict is the result of a military intervention, the position of Mauritius is not aimed at targeting the Russian people, as the people-to-people relations are permanent whatever the circumstances are. In this respect, I wish to inform the House that I met the Russian ambassador in Mauritius. Indeed, Mauritius, as well as many African countries, recall that the 1960 UN Declaration Against Decolonization was introduced by the former USSR, then comprising inter alia the former Soviet Union, the former Soviet republics of Russia and Ukraine. The long-standing friendship between Africa and the people of Ukraine and Russia will once again stand the test of time. Mr. Speaker, sir, I wish also to inform the House that since 16 February 2020, a crisis cell to assist the Mauritians in distress in Ukraine was set up by my ministry to monitor the situation of Mauritian nationals, particularly Mauritian students in Ukraine, with a view to facilitating their repatriation. A hotline was also set up and a number of calls were received on that hotline. 2 communiques were issued to request our nationals in Ukraine to get in touch with the ministry and our embassies in Moscow and Berlin, as we were finding ways to come to their rescue. Some 10 Mauritian nationals studying and others living with their families in Ukraine were successfully repatriated. Some of the students were at Dnipro, Kiev, and Sumy. I would like to express my appreciation to all stakeholders for their crucial role in assisting our nationals trying to leave Ukraine and during their transit in Poland or Russia on their way to Mauritius. While on this chapter, I would like to pay tribute to the Mauritian diaspora, which not only helped in organizing the repatriation from Ukraine to border countries, but also provided food and shelter to those in need. This spontaneous support illustrates once again, if need be, the strong patriotic fiber of our fellow citizens, which invariably manifests itself in times of crisis. And it is in such dire times that the solidarity and patriotism should prevail. I should also emphasize, Mr. Speaker, sir, that from the start, we had contacted friendly countries for help, and we were monitoring their efforts as they were addressing the plight of their nationals and students trying to leave Ukraine. Here, I would like to thank all the countries which have responded positively to our call for assistance. And in the same breath, Mr. Speaker, sir, I would like to thank our 2 missions in Moscow and Berlin, who spared no efforts to promote support and solace to our Mauritian nationals. As regards the situation of the Ukraine families stranded in Mauritius, the government has requested compassionate consideration of extension of their stay in Mauritius, owing to the situation occasioned by the start of the war in Ukraine. In the same vein, following representation by the Ukrainian families and the Honorary Consul of Ukraine, the Ministry of Tourism is looking at possible options for alternative accommodation for their prolonged stay, if needs be, in Mauritius. Mr. Speaker, sir, the consequences of the Russia-Ukraine crisis are getting more complex as the situation worsens and remains still beyond the grasp of any measurable yardstick. On the human side, according to the UN High Commissioner for Refugees, 4 million Ukrainians have already left the conflict for Poland, Moldova, and Romania. A second wave of 4 to 5 million is expected to leave their country if the country lasts for an additional month. Any enduring conflict would lead to an international tragedy. So far, the conflict has claimed more than 10,000 lives, including a large number of civilians, and the destruction of infrastructure and human settlements have been unprecedented in Europe since 1945. On the economic front, the military operation led to the enactment of an unprecedented number of sanctions, freezing the assets of Russian entities and prominent Russian nationals by the US, Australia, New Zealand, South Korea, and Japan, and the European Union. The sanctions, as well as the switching of Russian banks from the SWIFT system, have the potential of disrupting the world economy in an unforeseen manner, adversely and indiscriminately affecting all countries. Indeed, due to the uncertainties and the indiscriminate impact of the sanctions, the United States and the United Kingdom have stated that the sanctions will be removed as soon as the conflict ends. In Africa and the Middle East, the impact of raising prices of commodities will have disruptive social and economic consequences. Mauritius will not be spared by the adverse impacts of these conflicts, and my ministry is participating in several interministerial committees which have been judiciously set up by the Prime Minister to monitor the situation and help in finding ways and means to mitigate the impact thereof. Conscious of the fact that the import of various commodities will be impacted by the conflict, the government is identifying alternative sources of imports so as to ensure that there be no disruption in the supply of basic commodities. Likewise, we are exploring ways of assisting our nationals in Russia with respect to impediments regarding transfer of funds. The inherent situation is compounded by the fact that insofar as commodities are concerned, the world has a reliance on Russia and Ukraine for the import of wheat, maize, and sunflower oil, supplying half of the world wheat and 3/4 of sunflower oil and 1/4 of maize supply. With the conflict in Ukraine, the global economy is taking a double hit after the recession caused by the COVID-19 pandemic, where we are seeing increases in price of commodities, natural gas, and fertilizers. Added to that, Mr. Speaker, sir, the economic sanctions imposed on Russia are worsening the situation even further. We are already seeing turmoil in financial markets with increased market volatility, but the full impact is yet to be determined. Furthermore, restrictive measures on airspace and security concerns are complicating all trade routes going through Russia and Ukraine. The conflict will thus likely have a negative impact on global air freight capacity and raise air cargo prices as carriers are forced to take longer routes and spend more money on fuel. With increased financial volatility, complex global supply chain reconfigurations, and mounting trade costs, the global economic outlook is very gloomy. Sir, should the conflict linger, countries like Mauritius, which are fuel and food import-dependent nations, may see worsening balance of payments and rising inflation. The combination of very high prices of food and fuel and the inevitable macroeconomic tightening will place severe pressure on the economy, and economic growth may be affected worldwide. Faced with the current situation, our government has already met with relevant institutions to assess the impact of the Ukraine-Russia crisis on our economy. A working group is considering the different responses to address high inflation in the short run, while at the same time promoting conducive macroeconomic conditions for economic resilience and recovery. But the impact on Mauritius of the Ukraine-Russia conflict, sir, will depend on the duration of the conflict and on inter alia, the consequences of our main trading partners. Mr. Speaker, sir, war has never been a solution to conflicts, and civilians have always been the first victims. This reminds me of a famous quote: "Since wars begin in the minds of men, it is in the minds of men that the defenses of peace must be constructed." This is what the Republic of Mauritius, led by our Prime Minister, believe in. This is why, sir, we have consistently urged all parties concerned to take the path of consultation and dialogue with a view to de-escalating the situation and finding a lasting solution which will address the concerns of all sides. I thank you for your attention.
Public bills, first reading.
Speaker, sir, I move that the national flag, arms of Mauritius, national anthem, and other national symbols of Mauritius Bill number 1 of 2022 be read a first time.
Mr. Speaker, with your permission, I move that the Landlord and Tenant Amendment Bill number 2 of 2022 be read a first time.
Motion seconded.
Motion.
Monsieur le Président, c'est avec beaucoup d'honneur et de solennité que nous retrouvons les bancs de l'Assemblée. D'autant plus que cette rentrée parlementaire débute avec l'introduction d'une motion sur un sujet de grande importance, celui du recensement des logements et de la population mauricienne. Et à ce titre, j'ai l'honneur de présenter aujourd'hui, devant les membres de cette auguste Assemblée, la motion à voter en vertu de la section 9 de la Statistic Act de 2000, telle que modifiée en 2011 et en 2017. Précisément, la dite section stipule qu'avant de procéder à un recensement, le Président de la République doit, sous réserve de l'approbation par résolution de l'Assemblée nationale, prendre un décret à cet effet. Le décret peut alors préciser la date
ou les dates auxquelles ou entre lesquelles le recensement devrait être conduit. Monsieur le Président, avant de détailler le contenu de la motion, permettez-moi de dire quelques mots sur l'importance que revêtent les exercices de recensement. Comme nul n'est censé ignorer, Maurice possède une longue histoire et une grande expertise en matière de recensement. En fait, le premier recensement national complet effectué à Maurice date d'il y a près de 300 ans, en 1735 pour être tout à fait exact. Depuis 1851, les recensements ont lieu tous les 10 ans, sauf dans des cas, dans des circonstances exceptionnelles. Le recensement des logements et de la population de 2022 sera ainsi le 19e de la série. Je tiens à préciser que le recensement sera mené par Statistiques Mauritius conformément aux principes et recommandations par les recensements de la population et des logements, révision 3 des Nations Unies. Monsieur le Président, le recensement des logements et de la population est l'exercice le plus crucial que nous conduisons pour assurer la collecte d'informations sur des caractéristiques démographiques, sociales et économiques de la population et des ménages de la République de Maurice. Force est de constater que le contexte sanitaire et économique des 2 dernières années nous l'a brutalement rappelé. Alors que Maurice a été frappé par la pire crise de son histoire, le gouvernement mauricien, sous le leadership du Premier ministre, a formulé une série de politiques publiques efficaces sur la base de données tangibles. C'est notamment à l'appui des statistiques que ce gouvernement a pu freiner les vagues de la Covid-19 tout en protégeant les ménages et en accompagnant la reprise économique. Je rappelle volontiers que Statistiques Mauritius, avec le concours de la Banque mondiale, avait dès les premiers mois de la pandémie conduit des enquêtes téléphoniques auprès des ménages mauriciens pour mieux appréhender les effets socio-économiques de la Covid-19 sur la population et les opérateurs mauriciens. Ces données avaient grandement contribué à aiguiller notre réponse face à la crise pour toujours mieux protéger la population dans un contexte en rapide et permanente évolution. Une réponse historique et efficace qui, je le souligne, a été la 4e plus importante au monde selon la Banque mondiale. Monsieur le Président, le recensement à venir va guider notre action. Il permettra de mettre en exergue des situations ou enjeux de premier plan, souvent complexes à saisir sans de tels outils. Je cite volontiers le grand mathématicien Henri Poincaré qui disait, avec beaucoup de véracité, « Le monde et la science ont leurs données propres, qui se touchent et ne se confondent pas. L'une nous montre à quel but nous devons viser, l'autre, le but étant donné, nous donne les moyens de l'atteindre. Pour prendre les bonnes décisions, il est essentiel de disposer de données de qualité périodiquement mises à jour. Sans recensement méthodique et régulier, il serait périlleux, sinon pernicieux, de formuler des politiques publiques adéquates pour répondre aux enjeux qui se cachent derrière ces données. Monsieur le Président, le recensement à venir que nous soumettons au vote de l'Assemblée sera effectué en 2 phases. D'abord le recensement des logements, puis suivra le recensement de la population. Sur le premier point, nous proposons d'entreprendre le recensement des logements de 2022 entre le 30 avril 2022 et le 20 juin 2022. Le recensement des logements permettra de recueillir des informations sur l'emplacement, le type et les caractéristiques des bâtiments, des unités de logement et des établissements commerciaux et industriels, ainsi que sur les conditions de vie des ménages, notamment les équipements du logement et l'accès à l'électricité, à l'eau et à Internet. Il couvrira quelques 400 000 ménages et environ 260 000 établissements. Quant au recensement de la population, il est proposé de le réaliser entre le 19 juin 2022 et le 1er août 2022 auprès de toutes les personnes vivantes à minuit dans la nuit du 3 juillet 2022. Le recensement de la population permettra de dénombrer la population résidente de la République de Maurice et ses caractéristiques géographiques, démographiques, économiques et éducatives, telles que la composition par âge, le niveau d'éducation, l'emploi et les situations de handicap. Il fournira également des informations sur le niveau de développement des circonscriptions municipales et des zones de conseil de village. Ce recensement couvrira une population d'environ 1,3 million d'habitants. Monsieur le Président, les informations recueillies lors du recensement seront une aide précieuse pour le gouvernement, le secteur privé, ainsi que pour les ONG. Les informations provenant du recensement des logements permettront au gouvernement d'orienter sa politique du logement vers les plus vulnérables et d'implémenter les programmes de logements sociaux avec efficience et efficacité. En outre, le secteur privé pourra s'appuyer sur ces informations nouvellement mises à jour pour sélectionner des sites appropriés pour l'implantation d'installations industrielles, commerciales et de services, ainsi que pour le développement commercial de logements résidentiels. Par ailleurs, en ce qui concerne le recensement de la population, les informations recueillies sont utilisées par les autorités mauriciennes compétentes à des fins d'élaboration de politique, de planification et d'administration, tandis que le secteur privé mettra à profit ces données pour prendre des décisions avisées en matière de production et de fourniture de biens et de services. Quant aux ONG, elles tireront bénéfice de la conduite de ce recensement en ciblant toujours plus finement leurs interventions et programmes d'assistance auprès de ceux qui en ont le plus besoin. Monsieur le Président, à l'instar de la stratégie du gouvernement en matière de transformation numérique, ce recensement sera placé sous le signe de la digitalisation. En effet, Statistics Mauritius utilisera pour la première fois des tablettes et des logiciels informatiques appropriés pour collecter les informations reçues. Je tiens ainsi à remercier chaleureusement le gouvernement de la République du Kenya et en particulier le Bureau national des statistiques du Kenya qui a eu l'amabilité de prêter gratuitement quelques 8000 tablettes pour les besoins du recensement. Nous remercions également l'UNFPA, le United Nations Population Fund, qui a pour sa part facilité cette collaboration. En ce qui concerne le logiciel qui sera utilisé, Statistics Mauritius a développé l'application CAPI, Computer Assisted Personal Interviewing, avec l'assistance technique du US Census Bureau et des consultants de l'UNFPA. Par ces deux biais, nous rejoindrons ainsi la Ligue des pays qui utilisent les avancées technologiques pour la collecte des données. Cela permettra une collecte de données plus précise et plus fiable, ainsi que l'obtention accélérée des résultats. Monsieur le Président, sur la base des consultations menées avec différentes parties prenantes et au regard du contexte mauricien ayant largement évolué depuis le dernier recensement de 2011, nous proposons d'ajouter un certain nombre de nouvelles questions au recensement à venir. D'une part, pour ce qui est du recensement des logements, nous proposons l'introduction de 6 nouvelles questions, à savoir, la première question additionnelle consistera à savoir si le bâtiment fait partie d'une zone de morcellement. Ainsi, des informations seront obtenues sur le profil des habitants de ces zones. Deuxièmement, la question additionnelle consistera à savoir si le ménage dispose d'équipements modernes tels qu'un réservoir de récupération des eaux de pluie, un puits d'absorption des eaux de pluie, un bac à compost, un climatiseur, un four et une voiture. La troisième question additionnelle consistera à connaître la disponibilité de parking et le type de parking. La quatrième question additionnelle consistera à recueillir des informations sur la distance entre une maison située à côté d'une rivière ou d'un canal et cette dernière. En relation avec la quatrième nouvelle question et la disponibilité d'un puits d'absorption pour évacuer l'eau de pluie, la cinquième question additionnelle consistera à savoir si la maison a déjà été touchée par une inondation. Et enfin, la dernière question qui sera introduite consistera à savoir si la personne a accès à un espace extérieur pour des activités de loisirs et la proximité de cet espace par rapport à la maison. D'autre part, en ce qui concerne le recensement de la population, la première question additionnelle consistera à savoir si une personne du ménage a été déclarée à la Civil Status Division. Cela nous aidera à avoir des informations concrètes sur la portée du nombre de personnes non déclarées. La deuxième question additionnelle consistera à savoir si le réseau Internet est utilisé dans le cadre du travail à domicile, à des fins éducatives ou à d'autres fins. La troisième question additionnelle concernera la participation des membres du ménage à une activité physique ou sportive. La quatrième question additionnelle consistera à savoir si des membres du ménage effectuent un contrôle médical régulier. La cinquième question additionnelle portera sur le pays de naissance et la date d'arrivée des personnes qui sont venues s'installer à Maurice. Et enfin, la sixième et dernière question à introduire portera sur des Mauriciens qui ont émigré, leur pays de résidence, la date de leur départ, la raison de leur départ et leur niveau d'instruction. Monsieur le Président, le coût total de la réalisation de ce recensement est estimé à 365 millions de roupies et mobilisera quelques 8000 personnes sur le terrain. Les dispositions appropriées ont été prises dans le budget en cours ainsi que dans le budget indicatif pour l'année fiscale 2022-2023. Je tiens à rassurer les membres de la Chambre ainsi que la population sur le fait que Statistique Mauritius prendra les mesures nécessaires pour minimiser les contacts entre les ménages et le personnel du recensement. Le personnel observera l'ensemble des protocoles sanitaires en vigueur, tels que la distanciation physique, le port du masque et l'application de désinfectants pour des mains afin de minimiser les risques de transmission du virus de la COVID-19. Monsieur le Président, sur ces considérations techniques, je conclus mon propos en réitérant l'importance de la tenue régulière de tels recensements. Les données qui en découlent nous permettront d'implémenter plus efficacement notre programme socio-économique pour faire de Maurice un pays toujours plus développé, toujours plus résilient. À l'appui de ces statistiques et conformément à la vision portée par l'honorable Premier ministre, nous atteindrons les objectifs de développement robuste, inclusif et durable que nous nous sommes fixés. C'est en ce sens que le recensement des logements et de la population mauricienne en 2022 sera une nouvelle pierre à l'édifice national que nous bâtissons ensemble. Mr. Speaker, sir, I move in terms of the motion standing in my name. I move.
Seconded. So, 17 now. Honourable members, I'll suspend the sitting for 45 minutes.